the Chairman of the Ways and Means Committee, Kevin Brady, for the purposes of an opening statement. Mr. Chairman.
Thank you, Chairman Buchanan, for holding this important hearing and for your leadership of the Tax Policy Subcommittee. And thank you to all of our witnesses for being here as well. We're here today to begin charting a new path forward on temporary tax provisions. In Washington, they call them tax extenders. For too many years before our historic tax reform, the approach to handling these provisions has centered around what works for Washington, not what works for the American people. In many cases, these tax extenders were a symptom of a much larger problem, our nation's outdated and uncompetitive tax code. High tax rates often drove both the supply and the demand of these short-term provisions. So rather than allowing our families and our job creators to keep more of their income up front, Washington forced them to rely on these credits, these exclusions and exemptions for short-lived relief. Meanwhile, the real problem, our nation's broken tax code, went unaddressed and grew worse. That's no longer the case. Today we have a new tax code that's modern, competitive, and built for growth. We have lowered tax rates for Americans of all income levels and businesses of all sizes. We've taken unprecedented action to encourage and reward investment throughout our economy, not just for a few industries, but for all. We've delivered one of the most competitive tax systems in the world, leveling the playing field for our businesses and workers across the globe, and more importantly, here at home. So the question now is, with all the outstanding features of our new tax code, do we need to keep temporary provisions that are a relic of the old broken system? That's the question we're going to begin answering today as we move ahead with a new forward-looking approach on tax extenders that aligns with the principles and priorities of America's new pro-growth tax code. So starting right now, we're going to apply a rigorous test to these temporary provisions. We're going to take a close look at each of them, asking ourselves and our witnesses, are these provisions truly needed in the modern tax code? Do they amplify and complement the growth and competitiveness provided by our new tax system? And if the answer is yes, what other tax provisions are stakeholders willing to give up to make the extenders a permanent or a long-term part of our tax code? We built a new tax code for the long term. Temporary measures are rarely good tax policies. Those that don't pass these tax tests should be eliminated so we can continue our ongoing work to improve America's tax code, making it even more pro-growth and even simpler. This is Congress's opportunity to end business as usual with these tax extenders and find a way forward for permanence and long-term status for those that remain. I challenge committee members on both sides of the aisle to view these with fresh eyes. Let's work together to continue to craft the fairest and most competitive tax code in the world. Once again, I thank you, Chairman Buchanan, for calling this important hearing today, and I look forward to working together with all of you to continue our work of delivering a fair, simpler tax code. With that, I yield back.
Thank you, Mr. Chairman. Last year, Congress enacted the most comprehensive and sweeping rewrite of the tax laws in over 3 decades. With our modern pro-growth tax code now in place, we need to turn our focus to maintaining it and making further refinements and enhancements. We don't want to wait another 30 years for the next tax reform. Instead, our ongoing focus will be on continuing to make improvements to the tax code to promote growth, promote fairness and simplicity for all taxpayers. Today, we take an important step in that process by beginning to evaluate the set of provisions which have been renewed so frequently that they are most often called tax extenders. Contrary to our focus in tax reform on providing broad tax benefits for all taxpayers like rate reduction, full expensing, many of these expired provisions are targeted very narrowly to encourage certain activity for certain industries. Following our historic reforms, it should not be business as usual with respect to tax extenders. Now is the time to examine each one of these provisions one by one to determine whether and how they fit into the new tax code. That means taking a hard look at whether each provision provides value to the American taxpayer. For each provision, we will ask, what role does this provision play in the new tax code? If it's no longer needed because of the reforms that have been enacted, the provision should be eliminated. If the provision continues to play an important role in enhanced pro-growth tax reform, we should consider making it permanent. And in that case, we will ask those who benefit from the provision to consider what other tax benefits they'd be willing to forego in favor of having this provision made a permanent part of the tax code. To that end, we opened the door of the Subcommittee on Tax Policy to all stakeholders or groups interested in testifying on these provisions that were in effect through 2017 and are now expired. Over 20 individuals and groups have took us up on the offer. We are now looking forward to hearing from 4 panels of witnesses testifying today about these provisions and their roles in the new tax code in order to help us answer the key question I've laid out. Without further ado, let's get to it. I now yield to the distinguished ranking member, Mr. Doggett, for the purposes of an opening statement.
Thank you very much, and I look forward to working with you on getting a rigorous review of all of these provisions. This is a rather unusual hearing. Indeed, I suppose any hearing on taxes in this committee is unusual since we went through a period over the last year plus where it was deemed easier to pass bills without public hearings than with them, and to minimize public participation, including the participation of those who are affected most directly by various tax provisions, and of course to never hold the administration accountable by having any of its officials come and testify about their position on these measures. As Mr. Brady alluded to in his opening remarks, he actually told us that the enactment of the Republican tax law would make extenders unnecessary. He said he would be, quote, ensuring that we will no longer have to spend months each year debating temporary tax extensions. Of course, in prior years, we haven't really spent months debating them. Often they've been included with must-pass legislation at the end of the year, really questioning whether they provided very much incentive and certainly without very much oversight. In 2009, I was successful in getting provisions added to the extender bill that year requiring careful cost-benefit analysis of each extender. It never was implemented in fact. Today's hearing really seems to be focusing mainly on the leftovers and the left-outs, what was not deemed of sufficient value to include in the new tax law. We know that while we have the kind of open hearing process that should have been the process used during consideration of the tax law, that if we extended all 26 provisions that are the subject of the hearing, the cost over a decade would be a little over $90 billion. While that's nothing to ignore, it pales in comparison with the more than $2 trillion involved in the original tax law adopted without specific hearings. I hope that what we will see out of this hearing and the resulting process is that we either include tax provisions in permanent law or we eliminate them. The idea of leaving people year to year not only questioning whether they're extended but suspended is really not fair. And it also reduces any incentive value that any of these provisions may have. Certainly there's little incentive associated with retroactively applying a tax extender. I am particularly interested in hearing this afternoon from a number of witnesses in Panel 3. I'm interested in hearing all the witnesses, but in Panel 3, who will focus on the broader impact of these provisions and how they tie in with the tax law we've already passed. I think some are obvious for elimination, such as the racehorse provision. Some present closer questions. Indeed, there's the energy panel we're about to hear from. What a contrast between the way tax breaks were handled for fossil fuels, none of which were touched, one of which was actually expanded so that multinational oil companies would pay even less tax on income they earn abroad than other multinationals, but it has been many of the renewable energy provisions that have been left with uncertainty. If these merit inclusion or extension, if they merit extension, they merit inclusion on a permanent basis in the tax code. So I look forward to working with you, Mr. Chairman, as we evaluate all of these provisions, consider their overall impact, and I hope that this hearing will not be the last in looking at the implications of tax policy for our economy and the impact of what in fact happened as a result of last year's legislation. Thank you very much.
Thank you, Mr. Doggett. Now it's my pleasure to welcome our first panel of the day. Our first panel is focused on expired tax incentive pertaining to energy efficiency. First, we'll hear from the Honorable Rick Lazio, Senior Vice President of Alliance Group. Mr. Lazio served in Congress 93 to 2000. Welcome back.
Thank you, Mr. Chairman.
And we are delighted to have him appearing before us today. Second, we'll hear from Henry Chamberlain, President and Chief Operating Officer of the Builders, Owners, and Managers Association International. Third, we'll hear from Daniel Bezet, Vice President for Policy and Research at Alliance to Save Energy. Fourth, we'll hear from Lisa Jacobson, President of the Business Council for Sustainable Energy. Finally, we welcome Sam Purcell, Chief Executive Officer of Zero Motorcycles, Inc.,